Welcome back to the conference. My name is Paul Berman, and you're going to be very tired of me by the end of today because I both chair this next collection of papers and have my own paper after that. This is the panel on constitutional arenas, and we're going to be focusing on the economic system, the intellectual property system, and the environmental commons as our three constitutional arenas. 4 papers, but 3 arenas. And I think it's useful to try to focus on some specific arenas. I confess that although this is I join with probably everyone in this room at admiring the extraordinarily generative ideas that Gunther puts out into the world. His ideas spark other ideas, spark associations, and generate creativity, which is one of the highest compliments one can give, I think, to a scholar. On the other hand, I'm not always sure I understand what he actually means. And in this case, I'm not sure I understand still exactly what societal constitutionalism is, although it sounds really interesting. And I'm pleased to be able to discuss it. And so one of the things that I think is useful is to try to apply some of these ideas or try to think about what societal constitutionalism might mean in actual settings. As I'll talk about later in my paper, come from legal pluralism, and the idea of legal pluralism is that there are multiple settings where law or quasi-law is constructed. Those settings can be international, transnational, state, sub-state, epistemic, and non-state, and that there are multiple fora where law and various normative systems can collide with each other, and perhaps societal constitutionalism is a way of understanding those collisions among multiple social systems, among multiple normative communities, and if that's true, and if that's at least one of the things that we should be doing in analyzing what societal constitutionalism might mean, then it seems to me we need more thick description of how these various collisions among multiple normative communities or multiple social systems actually play out. And so I'm hoping that today, both in the papers that we're going to hear this morning and in my paper later, we'll have an opportunity to discuss what that might mean, what societal constitutionalism might mean in various actual local settings, or at least specific settings, if not territorially local. Just to pace ourselves, there's a slight change from the program, which is we're going to hear one paper, and then we get our coffee break. So just so you know that more coffee is coming very, very soon. And so we're going to start with Moritz Renner, professor at Humboldt University in Berlin. He has written a PhD dissertation on international arbitration and focuses on transnational corporations and credit contracts, and he's going to talk to us about the economic system and why societal constitutionalism either works or doesn't work as a way of describing our transnational economic governance system.
Well, thank you very much for the great introduction and also for the opportunity to speak here as we enter the constitutional arena of the economy. Ladies and gentlemen, the central constitutional question of the 20th century has not been the limitation of political power, but the taming of economic power, and the question of how to reconcile the unleashed functional rationality of the economic system with claims to political autonomy. Now, Gunther Teubner's theory of societal constitutionalism poses this constitutional question anew against the background of a globalized economy in a state of recurring crises. And my contribution indeed seeks to be a critical application of the theory of societal constitutionalism. And I will try to apply this theory to the concrete example of transnational standard setting in corporate accounting. And at the same time, I will try to evaluate some of the theory's central tenets. So, in order to do so, I will proceed in 3 steps. In the first step, I will briefly sketch the ideological background of the theory of societal constitutionalism in order to better understand its direction and aims. And in a second step, I will try against this background to carve out the theory's central tenets with regard to the relation of constitution and the economy. And then in a third and maybe the most important step, I will try to apply these tenets to the concrete example of transnational corporate accounting. So, as to the first step, the ideological background of the theory. In my paper, I try to identify 2 ideal typical lines of thought, which I think are particularly important for the theory of societal constitutionalism. And that is, on the one hand, the theory of economic democracy, and on the other hand, theory of economic constitutionalism. I cannot go into the details of those 2 theories, but I will just briefly sketch those approaches. What those approaches have in common is that they both try to develop a third way between laissez-faire liberalism on the one hand and socialist planned economies on the other hand. And what they also have in common is that they both try to frame conflicts between the economy and politics in constitutional terms. So, the first of these lines of thought, the theory of economic democracy, sometimes also referred to as industrial democracy, particularly in the UK context, was developed already in the 1920s by reformist socialist thinkers and social democrats, and it claims already in the 1920s that the economy can no longer be controlled by the democratic institutions of the nation state, and that therefore the economy itself should be democratized. So, how this democratization should work in practice remains rather vague, actually, as does the underlying concept of democracy and the political. And mostly the theory translates into a rather moderate reformist agenda, focusing on the strengthening of state employment law and workers' co-determination. But what I think is important about this theory, and what is important to the theory of societal constitutionalism, is that economic democracy claims that the economic system can at least selectively be open to inputs from political discourse. So that's what I think is important about this first line of thought. As we look at the second line of thought, the theory of economic constitutionalism, we have a quite different starting point. The theory of economic constitutionalism was developed around the same time in the 1920s, and it was developed by ordoliberal thinkers, and it starts from the assumption that the economy is an autonomous social system, so the economy can in no way be steered or governed by political action. The theory of economic constitutionalism, however, sees the self-destructive and socially disruptive effects which arise from the concentration of economic power. And therefore, and I think that is the important contribution of the theory of economic constitutionalism to the theory of societal constitutionalism, is that it develops the idea of a genuinely legal constitution of the economy, with law as a mediating instance between economy and politics. For example, through a strict competition law, which both prohibits political distortions of market competition and the concentration of private economic power. So much of political discourse in the 20th century has oscillated between those two lines of thought, economic democracy on the one hand, economic constitutionalism on the other. And I think the Western European welfare state of the 20th century, we have discussed this yesterday, can be seen as a kind of historical compromise between those two lines of thought, combining an ordoliberal model of market competition with social democratic achievements such as workers' co-determination. And in the last decades we have seen this historical compromise beginning to erode and being replaced by what Colin Crouch describes as a strange amalgamate of Chicago school neoliberalism and Keynesian state interventionism. So the interaction of economy and politics is no longer framed in constitutional terms, but rather the very boundary between politics and the economy begins to blur, for example through rescue packages and state-subsidized banks. So how does Gunther Teubner's theory of societal constitutionalism fit into this ideological debate which I've just sketched? In his book on constitutional fragments, Gunther Teubner expressly rejects both approaches, the ideas of both economic democracy and economic constitutionalism. But at the same time, and I find this much more interesting, he also attempts to combine both theories. On the one hand, he shares with economic democracy the aim of democratizing social spheres beyond the political system, such as the economy. And on the other hand, he shares with economic constitutionalism the idea that society's divergent functional rationalities are both constituted and limited by rules of law. So the resulting normative agenda of the theory of societal constitutionalism is what I want to express with this catchy phrase of occupy the system. Through an internal politicization of social systems, those social systems shall be allowed to both reflect and subvert the limits of their functional rationalities. I will not go into the details of and the intricacies of the distinction between politics and the political, which is developed from here, but what I found interesting is that the theory of societal constitutionalism actually aims at a theoretical reconciliation of economic democracy on the one hand, economic constitutionalism on the other, and it at least might spur the hope that we might actually transfer some of the achievements and learning experiences of the welfare state to social arrangements and institutions beyond the nation state. We've discussed this yesterday as well. And I would like to explain this in a concrete example, thus both generalizing the ideas of economic democracy and economic constitutionalism, and also re-specifying them by way of application to a concrete example. And the example I've chosen for this presentation is the case of transnational standards in corporate accounting, or more precisely, corporate financial reporting. So, why this example and what is corporate accounting? Well, rules on corporate financial accounting exist since the 17th century, and they are of paramount importance to all market economies which are based on corporate actors, and they are important in two different respects. First, they enable a regulatory oversight over companies through reporting requirements. And second, they serve as a central information device for investors in the market through those information reporting requirements. And what makes the example interesting for our purposes is that this standard setting process in corporate financial reporting has been almost wholly privatized in recent decades. So global accounting standards are set by the IASB, that is the International Accounting Standards Board, which is a private entity with its seat in London. And the standard set by this IASB, the so-called IFRS, which stands for International Financial Reporting Standards, are made in an almost ideal, typical transnational legal process. So they are set by a private body, but they are recognized by public legislation. They are global in scope, but they are incorporated into domestic law. And although they are universal in reach, they are limited to a very specific issue area. That is the issue area of corporate accounting. However, and some of you will know this, in the course of the financial crisis, those IFRS standards have been heavily criticized, and especially the so-called principle of fair value accounting, that is the principle that a corporation's assets are evaluated according to their current market value, has been criticized for its alleged pro-cyclical effects, and thus for its effects in worsening the destructive cycle of the financial crisis. So the practical question arising from this, the practical question for the theory of societal constitutionalism is, how can such criticisms and concerns be addressed within the transnational standard setting process? So can this process be constitutionalized in a way that makes it possible to address such concerns? And in order to answer that question, I think we need to be quite clear about what we mean by constitutionalization. And I think the theory of societal constitutionalism centers around two features of modern constitutions, which are developed from a combination of economic democracy and economic constitutionalism accounts. And I think those two features are, on the one hand, the emergence of a hierarchy of legal norms, and secondly, a structural coupling. We've discussed this, this concept yesterday, between economy, law, and politics. So I will explain those two features. As to the first feature, normative hierarchies, hierarchy of legal norms. What do I mean by this? I mean that transnational legal processes develop secondary rules of law in the sense of HLA hard, that is, rules on the lawmaking itself. So what you see here in this very colorful graphic is the internal structure of the IFRS Foundation, which is the umbrella organization of the IASB. And this internal structure is laid down in a document which is expressly called the IFRS Constitution, interestingly. And what this document does is exactly the establishment of secondary rules of law. So this constitution regulates the competencies of the bodies, regulates modes and procedures of decision-making, it regulates majority requirements, especially a majority requirement of 75% for changes to the constitution itself. So all these are features which are very much comparable, I think, to the organizational provisions in nation-state constitutions. So that is the first feature which I think this IASP standard setting procedure exhibits. It establishes secondary rules of law, rules on lawmaking. But what about the second feature of modern nation-state constitutions, which I have described? That is the structural coupling of law, economy, and politics. And in order to explain what I mean by this, we must take a closer look to the standard setting procedure itself, which you see on this slide. What I think is pretty clear is that this standard setting procedure leads to a coupling of economy and law in the sense that it fixes the economic rules of the game as rules of law. But the interesting and more important question maybe is, how is this process, this economic legal process, coupled to the political system? And I think that was our main source of concern in yesterday's discussions as well. And in this respect, it is important and interesting to see that the IFRS constitution foresees that all IFRS standards before their adoption must be published as a so-called exposure draft. And this exposure draft is then subjected to an inclusive public consultation procedure according to the so-called due process handbook. So how does such a consultation process look like? When we look at the statements of stakeholders in this process, which are all published on the internet, we can typically observe the participation of really several hundred stakeholders, including large corporations such as Apple Incorporated or Shell, business associations, NGOs, public regulators, academics. And what's interesting when we closely look at their statements is that they put forward their positions not just as particular private or public actors, but that they constantly make claims as to their representativeness for a certain sector. And that they not only refer to particular interests, but also to public policy objectives. So what happens here is what I would see as defining for a process of politicization. So the fact that power, in this case economic power, is not only limited, but it is effectively transferred from the economic system of market competition into a kind of political discourse through this public consultation procedure. So to sum up my presentation, as I'm coming to the end of my time, I think the example of transnational standard setting in corporate accounting shows two things. The first, from an analytical perspective, I think it shows how we can fruitfully analyze transnational economic governance with concepts from constitutional theory. And second, from a more normative standpoint, I think that actually the hope of societal constitutionalism, the normative hope it embodies for a reconciliation between economic democracy on the one hand, economic constitutionalism on the other hand, might actually be fulfilled in transnational practice. So thank you very much.
Okay, question.
I want to come back to maybe your first part. I can remember first. But,
as you know, the international accounting standards, it took quite a bit to formalize and to get consensus. Certain countries, China, chose to adopt, one might say informally, these standards in 1993. Japan was active in the global economy, did not, adopted them in 1997. However, its firms were adhering to the standards of basically the American. how does this kind of stuff fit into your analysis? Because there is an interesting, now when I say China, it's the government of China representing the interests of state, at that point mostly state firms. So China is a very specific case. But we see that in other countries as well. One of the last ones to adopt them were the Americans, of course, you know. So I'm absolutely fascinated by what you have selected, you know, that one point that you're looking at, when the process is actually generating the norms, and then this notion that if you want, the preferences, to put it mildly, of economic actors get circulated as representative, etc., and then they become part of a policy process at least.
Yeah. Well, I think what you are alluding to is like the remainder of state sovereignty involved in this process, and I've reflected on this in my paper, but largely left it out of the presentation. And as you can see in this slide, there is a jurisdictional adoption process of the IFRS standard. So there's still a role for nation states to play, and it's absolutely right that we had a difficult process in adopting these standards at first, and then when important players like China, like Europe, adopted those standards, then only they achieved like global effect. And I wouldn't say that the nation state is left out of the loop in this process, and the process has certainly been triggered by nation states, and it is fostered by nation states, and the standards are accepted by nation states. But it's also interesting to note how this acceptance takes place. For example, in the European Union, we have kind of a regulation which says that all the IFRS standards are given force of law in the European Union without any modification by the European legislator. So this process is enabled by national legislators, but then kind of makes a lift off from this national level and develops its own.
Yeah, what I'm asking is, what I was arguing yesterday about finance is that finance uses the state to circulate what it needs, its conditionalities. And I'm hearing you say something very similar. Is that correct, or am I a bit more brutal then?
No, I would agree to that.
Oh, yes. Thank you for an interesting presentation. I was wondering, the stakeholder form, that is basically the form of the political you see, but that is obviously a different kind of politics than the nation-state form, for example.
Yeah.
What is the concept of the political lying behind, so to say? There must be some kind of generalized conceptual form of what kind of, because this is basically just a format for reflexivity, no? Like, that's what it does. It increases the reflexivity of this organization, its environment. But is that politics? Is that your definition of politics? That to increase reflexivity? Or is there any kind of more or less demanding concept of the political behind? And also, in a more internal system theoretical concept, you're talking about triangular structural couplings, law, politics, economy. I'm not personally a Lumanian. I think Luhmann made a wrong diagnosis of society, but I'm still a systems theoretian, because it's two different things. But in the Lumanian version of systems theory, you can only work with binary couplings. So such a thing as triangular structural couplings doesn't really exist in the architecture of you find in classical systems theory, which means you will actually have to reconstruct the theory quite substantially if you want to use this kind of vocabulary to talk about triangular couplings. And I wonder where the theoretical basis for this exercise lies, so to say. Thank you.
Yeah, well, thank you for the interesting questions. And as to the first question, the underlying concept of political, I think I have a very broad concept of politics, and I think politics for me is all communication which orients itself in the medium of power. So that is my concept of politics, and I don't make a distinction differently from Gunther Taubner between politics and the political. So politics is not reducible to institutionalized politics, but all forms of political communication. That is communication in the power medium. As to your second question, the idea of a triangular coupling between economy, law, and politics, I don't think that there is a triangular coupling. I think we have two distinct binary couplings. We have a coupling of the economy to legal processes, as we can observe in transnational legal processes. And then we have the question whether these legal processes in the transnational arena are in their turn coupled to some kind of political discourse. So there's a triangular constellation, we might say.
Not a triangle, it's a chain.
It's a chain, yeah. It's actually a chain. And that's what makes the theory, I think, pretty close to economic constitutionalism, because it sees law as a mediating instance between the economy on the one hand and politics on the other hand. So there's no direct interaction, or almost no direct interaction between economy and politics, but it is mediated through legal structures. And I think that is what we can observe in such decision-making structures as are exposed by the IASB, for example.
But if it's a chain and not a triangle, what is then the causality, so to say? Because does it go from politics to economics via law, or the other way around?
Yeah, well, I mean, in system theory, there's no causality, actually.
Yes, that's the easiest conclusion to say, yeah.
That's the easy answer, and the more complex answer would be that I think at one point the economic system will be faced with problems of complexity it cannot itself solve. And that is why the rule-making process, making the rules of the economic game, is externalized to the legal system. And then we have the same kind of complexity problems internal to the legal system, which accounts for the rise of state constitutions, actually, as Luhmann explains it, as an evolutionary process and kind of regulating and ordering the internal complexity of the legal system.
Okay, we have Florian, Larry, an audience member, and
my question are much more basic. I like the first part very much, with this contrast of economic constitutionalization and economic democracy, but I have some problems understanding the clue of the second part, which is probably a proof of poor understanding. You talk about hierarchy, and in my view then, you show that this organization fulfilling a quasi-legal function has a statute process that regulations that says how decisions are taken. I mean, this is very particular for any institution and organization has to take decisions. So is there something, it's only this, and this is then worth to having such an emphasis? So whenever you put an organization in place, it will have a hierarchy of norms, which, so maybe I missed something. Did I miss the clue, or is that the story? Second, structural coupling. You refer to what is on the slide. You refer to basically what is on the slide. Now, again, this accounting board fulfills a quasi-legal function. It could have been done by the state, but they referred to this organization. So what is so special that they adopt quasi-legal culture of deliberation, or a quasi-political procedures of discussing, exposing it to the public, reacting to criticism, and so on and so forth? And in which sense had anything to do with economic democracy, because the economic democracy is not about legal framing economic activity, but it's about property rights. And I cannot see any link to this.
Okay, as to the first question, I would certainly agree that most organizations, rule-making organizations, at some point develop secondary rules of law. So they must have some organizational rules on their own rule-making procedures. I think that is a defining feature of constitutions, be it state constitutions or organizational constitutions. But it is not sufficient to describe the concept of constitutionalism. And that is what I think we need the second feature of constitutionalism, and that is the structural coupling between law, politics, and third social subsystem, in this case, the economy. And it's certainly debatable whether this kind of political consultation process fulfills our normative concepts of democracy. But what I find important here, and that's how I read the theory of economic democracy as it is put forward by Naftali and others, is that we develop structures for opening the economic process, in this case through legal structures, and that is not so different actually from workers' co-determination and determination.
Accounting and not about it's only accounting. It's not about investment. It's not about something else.
Yeah, but I wouldn't say it's only accounting, because the role of accounting in the financial crisis has really been paramount. I mean, that's the foundations of our system of financial economy, and that's why I'm interested in what the theory of societal constitutionalism might offer in way of understanding these structures as being open for politicization, democratization.
Okay, we have Larry, the audience member, Uzo, and Christian. Larry.
Thank you for a really great presentation. I don't have a critique. You've made me think about a couple of things, and I was wondering maybe you could walk me through from your paper to these other things. I was taken with your binary on your description of societal constitutionalism between economic democracy versus economic constitutionalism. But I wonder whether your description of economic democracy is fairly anemic. You're good at binding it to its fairly doctrinal, mostly European versions, but that eliminates a couple of other, maybe more robust and perhaps more interesting interventions. Everything from the Spanish anarchists of the 20s and 30s, whose views are, which is where I thought you were going to the Occupy title, which for me was a direct line back to Spanish anarchist writings and the economic organization in the 30s, and also its more institutionalized, more bureaucratized version in the form of Chinese or Cuban Marxist-Leninist organization, which also means to politicize, but they're democratic dictatorship. And I was wondering whether, to what extent, if you fold that into your notions of economic democracy, you might wind up moving your theory in a little more complex, interesting ways. And the second thing is a point that Florian brought up that I was hoping you might explore. Your description of the accounting was kind of, my sense was that you chose the kind of techno-liberal approach in describing the institutionalization of an internally self-validating program, and you describe its borders fairly narrowly, controlled by the state. Transparency, you didn't say communication, although you used structural coupling as a basis, but I'm wondering, in a sense, and this is in your colloquy with Florian, you kind of brought it up, we're not really dealing with a techno-liberal concept here. Accounting is, in a sense, quite literally the way corporations incarnate themselves. It's the only way you can see them or feel them. And so there's an extraordinary normative element to this, which is belied by the sort of technocratic rulemaking that is exposed by this kind of, again, anemic system. But nothing in here about what the printer might have called the collisional aspects involving the discussions of basic normative standards. For example, all of this presupposes privileging of financial reporting, but marginalizes social, environmental, and human rights impacts of reporting that might reconstitute these entities in very, very different ways. You'd see them, they'd be incarnated of very distinct animals. So I was wondering if you can kind of talk about both of those things.
Okay, I think your first question goes in a similar direction as Florian's. I mean, you said I had an anemic concept of economic democracy, and I would certainly at least agree to the extent that I'm certainly coming from a certain tradition of economic democracy, and that is in a way very much indebted to the Weimar Republic concept of an economic democracy and does not reflect like more radical approaches, be they anarchist or Marxist, Leninist. So that is the point I'm starting from. And also, I think I'm taking this point only as a starting point for a reconstruction of the roots of societal constitutionalism. And I think that is the roots that this theory is adapted to, and I wanted kind of to lay open these roots. And as to your second question, the question of technicality and the potential for a reflection of more normative issues in this process. I mean, it is an open question whether this consultation procedure on the one hand, and on the other hand, the fact that those standards are adopted by jurisdictions and need to be adopted by national parliaments allows for a reflection of such concerns, be they social policy concerns or environmental concerns. And I wouldn't make a final statement as to this issue. What my purpose was to identify the points in this process where we might see a politicization.
Yeah, an audience member.
So my question goes in the same direction as the other two questions, because my suspicion is that could it be that your conception is a little bit biased towards economic constitutionalism? Because, I mean, economic democracy is not only about opening the economy, but it is about the core of the economy, so private property, and putting private property at another kind of publicness, so not the state, but in the 1920s kind of workers control. And here would be my question. So also with regard to your example, so where is this fundamental democratic element in the processes of the ASB? Because a perspective of economic democracy would, I would say, always argue that there's only democratization if the very core of the ASB is at the disposition of democratic will formation. Maybe not in the statal sense, but in a societal sense. And this is the question. I mean, isn't that maybe a little bit provocative, kind of a false politicization taking place there? Or is it a real politicization in the sense of economic democracy?
Yeah, well, I mean, as your question goes in the same direction as the last two questions, I can only repeat some things that I've already said. I mean, I certainly think that my account of the theory is in a way biased in favor of economic constitutionalism, but I would say so is the theory of societal constitutionalism. And that is actually what I wanted to show. So as I said, I want to lay open the ideological or history of ideas roots of this theory. And as to the more normative question, whether this is a real politicization or a false politicization, I wouldn't make a definitive statement. So under the analytical perspective of systems theory and societal constitutionalism, we could say that there is a structural coupling between this economic leading process to political processes, but whether that fulfills our normative hopes of democracy, I don't know.
Okay, so we've got 3 questions. I want to collect all 3 questions. Ugo, Christian, and an audience member.
Okay, I have 2 questions. One very short though. One is you have said that the law is a necessary structure to mediate the relationship between economics and politics. I would very much disagree on that, and so perhaps I haven't understood well your argument. I would like you to put some thoughts about that. If there is a lot of relationship between economic and the political, it is completely illegal, outside of the legal domain. So it seems to me very weird as a statement. And the second question is more empirical. I'd like to know something more about the constituent element of your analysis, that is to to say this board, this accounting institution, foundation, when was it, what was the force behind its birth?
Yeah.
And who was out there, and why it was decided to make it? So give us some of the Grundnorm of it, because otherwise to make a constitutional claim seems to me without the grounding. Thanks.
Christian?
You have two questions which you may have in your paper, and you touched upon, but I'm not sure whether I got it right. The first is your world of economic constitutionalism. We had in the 70s, well, dead in the world, but we had an intense debate on Keynesianism and constitutionalism. And the thesis was macroeconomic management cannot be constitutionalized. Or, as the oral liberal said, it's illegal per se because it doesn't fit. Now, today we also have macroeconomic management, also not in a very democratic way, but through traditional, through regulatory politics. Now, I just wonder how this fits into your constitutional world. And the other thing which is on my agenda in all these matters is the asymmetries of the international system also within Europe. What does this mean to find a standard which fits to third world countries, to highly developed countries? Is this somehow integrated into your world of democratization?
And we have one question from Doug.
If you're using the example of this international standard as an example of societal constitutionalism, isn't the idea of societal constitutionalism that these standards are basically protecting function systems or these organizations against their own self-destructive tendencies? And if that's the case, then how did the financial crisis happen in 2008? That's one question. The other one, the meaning of that public consultation. Are these different publics? Who is the public there? Are these the publics of the stakeholder of these companies? And can we find a way to explain variation in that jurisdictional adoption process in the sense of that coupling of external and internal irritation? But why did different countries adopt these standards at different points? Were there different levels of public outcry for regulation of accounting, or was there lobbying on the part of the corporate managers? Or can you explain that?
Okay, so that's a lot of
or some of that.
it's a lot of very interesting and difficult questions. I tried to combine some of my answers. As to the first question of Ugo Mattei, which I think was also addressed by Christian Jürgens, the role of law as a necessary mediating instance between economy and politics. Well, of course, in social reality we see lots of cases where there is no law as a mediating instance, where we have direct political interventions in the economic process on the one hand, and on the other hand, direct reflections of
economic power structures in the political system. I do not deny this at all, but the question is what is a constitutionalized political economy in that sense? And I would say, and that is how I reconstruct the theory of societal constitutionalism, that a constitutionalized political economy is a political economy where we don't have those direct interactions, as they would amount to what systems theory would call structural corruptionism. That is pretty close actually to our common day understanding of corruption. Corruption is a prime instance where we have economic power directly translating into political power. And what any form of constitutionalism would do would be to avoid such kind of direct overspills from economic to political power. So as to your second question, the driving force behind the
the founding of the IFRS Foundation, it's pretty clear that from the 1970s on, actually, this process was driven by the US and the UK, basically, where the corporate accounting standard setting process was already privatized and had always been private, actually, and it is more actually a Western European specialty that this process would have to be driven by the state. So it was actually it was actually directly aimed at translating the Anglo-American model of private standard setting and corporate accounting to a global institution. And so maybe, as to your question of the protection of functional systems through constitutional structures, I would agree that this is actually the prime function of constitutional structures and social systems, but I would say that such protection can only succeed if at the same time those functional systems are selectively opened to other functional systems. So that's actually the concept of structural couplings. What it says is that only through a selective opening of functional systems we can preserve the integrity of those systems. If the systems can decide which inputs from the outside to reflect and which not to reflect. And maybe I would conclude with this answer.
Very good. Thank you so much, Moritz. And we'll have our coffee break and come back in 20 minutes. Turning from accounting standards to intellectual property regimes, we have Professor Don Vich, Chair for Legal Theory and Private Law in Cologne, and having received his LLM at the University of California at Berkeley. And his thesis is being published. It's on access rules and the constitutionalization of knowledge sharing, and how the intellectual property regimes affect knowledge sharing, and that's the topic that he's going to address this morning. Don.
Thank you for the introduction, and thanks to the organizers for having me. First thing, I want to give you a short idea of the genetics of constitutionalism, and then proceed to my main argument that deals with IP law and the governance of intellectual property. So when it comes to the problem of social order, that is, the center point for constitutionalism, in my view, then we can at least detect a model of centralized coordination of action in society. So what we experience is that social evolution instituted the sovereign state, right? And that is characterized by the monopolization of power. And if you want, in a rational reconstruction, such as delivered by Hobbes, that means that you exchange as a member of society your power for security. So you transfer your power to a central party, but you transfer only the power, the knowledge, and that will be important for the rest of the talk. The knowledge resides in the individual. The individuals still cannot transfer the knowledge to this central party. The central party only acquires the power to act. That leads to an enormous autonomization of politics. And in the same way, a centralization of lawmaking, because the political power is channeled backwards through society by positive law as a medium. So the rule of recognition, in the Hartian sense, is hosted exclusively within the state and no other entities. The result is that societally cooperation is reframed by this autonomously created center of collective action decision-making, and that is the state. So in the light of, again, social contract theory, you might say that cooperation is kind of rebooted by the law of the state. That is the very idea to found this institution. But this review of existing social institutions that comes with this idea causes follow-up problems, in the sense that you might perceive a pathologically expanding of this medium of politics into social autonomies. And there comes in the idea of the traditional idea of the political constitution that limits, oh my God, I forget to make you dynamically follow my ideas. There comes in the idea of the political constitution that is designed to limit, from a functional perspective, the political autonomy from infringing other social orders, most of all with the help of human rights, of course. But taking seriously the idea that there is a general change in the evolution of society that is affiliated to social differentiation, we might have to recognize that besides the autonomization of the political realm, we also have the autonomization of other social spheres. So I would say we have to take into account the multiplication of social autonomies, and that means that we have in parallel monopolizations of social rationalities, not only the political rationality, but also the scientific, the religious, and so on. So this decentralized model of coordination, because of the parallel monopolization of these rationalities in society, require an adequate constitutional answer. And I guess this adequate constitutional answer lies in the idea that that constitutions or the law has to preserve the integrity of the pertaining system's environment. Now, you don't only have to focus on policy and the political realm that is expanding into society, but to, decentralize your perspective and look from the pertaining system to the rest of society and apply the same idea of limitation as well. So there's no central political integration that you can rely on when it comes to deal with these problems. Instead, Luhmann said that we can experience a cognitive turn within the evolution of social society, and that means that we have to proceed to a learning adaptation of collision norms that are created decentrally within society. So the idea is that we might develop, instead of the classic constitutional law, a multilateral environmental law, and that would implement the notion of the constitution in the way that it is dispersed into a multitude of legal rules that aim at protecting the environmental conditions of systemic autonomy, right? Not the constitution, but the many environmental rules concerning the relationships between the pertaining system and its manifold environmental circumstances. But this also requires an adequate form of legal reflexivity that takes seriously the social multi-referentiality of rights. Rights shape the conditions for autonomous operations of various systems of meaning production. So the law must, in the moment the political system is unable to regulate these autonomies, become aware of a system that acts in a environment. You have to leave the doctrinal thinking of law that can replicate the environment just one by one, but you have to go for the idea that the law has to internalize its relationships to the outside within the law itself. So the law takes center stage in the moment the political constitutions get, dissolved in this transnational arena. I'm talking about the social multi-referentiality of rights, so rights of what kind? And then I proceed to the property part of my paper. Property rights, let's focus on these. They constitute not political autonomy, but they constitute economic autonomy. And the principle of multi-referentiality I just introduced requires us to preserve the integrity as lawyers of the economic environment. Not just the autonomization of economy, but preserve the integrity of the economic environment. But where to get the knowledge for this, adventure from? Where is the knowledge for the management of property rules? Can we put it in the hands of the collective sovereign? But the collective sovereign, at least as according to the constructivist model, is full of power but without knowledge. So the basic problem, I guess, is that political autonomy requires knowledge that only private autonomy can generate. And constructivist approaches are insensitive to this issue. So we have to shift to another approach, and that is a more evolutionary approach proposed by Hume, where the legal rules are seen as the outcomes of practical experience, of artifacts, of, in a way, standards in society. And that implies a kind of epistemological turn in the sense that we have to acknowledge that practical knowledge is dispersed among the individuals within society, first step. And second step, that individual decision-making rights make this practical knowledge available to others as a kind of positive externality. Because they produce patterns of experience that is stored in iterations of relations made possible by these private rights. So that means that property rules emerge where the knowledge resides, and that in a way you can say that the configuration of private autonomy takes place through social conventions, through social normativities, and not through any regulation of the state. The state starts maybe the system, but the rules, the legal rules, are created within society. So it's a difficult point, I know, but I would like to conceive, therefore, for a new concept of political autonomy. Where does political autonomy is left in this scheme? Political economy is left or is moved or transformed into the right to justification of alternative worlds that are created with the means of private autonomy. I have the right to create this world, and I have the right to get this world accepted, to be recognized, but of course this recognition has to apply to certain criteria, so that is a right to justification of these alternative worlds. I will talk on this later when I come to the point of recognition rules within IP review. So let me move to IP rights. IP rights, what's so special about them when it comes to compare them to normal property rights? Now, IP rights subject access to intellectual goods, to markets, to the economy. They grant chances to exploit the protected work within the economy. But that simultaneously affects knowledge sharing in other systems. Why? Because they prevent that other individuals can actualize the protected media and therefore also the protected knowledge, and apply it to their individual environment, to recombine this medially stored knowledge within their to their local knowledge within their environment. In my view, creativity creative activity depends on interpenetration of individual systems and social systems. Communications and consciousness, you see this environmental approach, are each other's necessary environment, and that is kind of neglected by traditional IP doctrine. Therefore, I would propose to reconceive IP law on the basis of a relation, and that is a relation between the individual consciousness system on the one side and on the other side on the social system, and not just on the individual consciousness providing this system with incentives to engage in creative activity, but because every protected work is also at the same time part of another social meaning world. It's a product of music, it's a product of literature. There it derives its aesthetic imperatives from, not from the economic system, of course, but at the same time, by installing exclusive rights, you intervene in this other sphere. That, for me, is the question of knowledge sharing, because, in abstract words, IP rights determine how individual observation capacity can be co-opted for a social system. That was heavily under-neglected in the Luhmann scheme, because he always concentrates on the emergent trans-individual sphere, but to go for these vertical structural couplings is a kind of lacuna in his scheme. So then the question is, how does IP law preserve the integrity of systemic knowledge sharing in the environment of the economy? That is the, if you want, constitutional question. And so I will turn to the governance of knowledge sharing. First idea, of course, is to look at international IP regimes, but there you discover that the integrating model of political integration is missing that would provide for a pluralism of aspects to be accounted for when it comes to create adequate law. So in very general terms, you can say that international treaties form self-contained regimes. They have the chance to form these self-contained regimes because the rationality of political autonomy, known from the nation state, is superimposed by the contractual rationality of the treaties. So the treaties don't have to provide for a plurality, but they can link exclusively to a certain social system. And they can couple, in the words of Luhmann, to a specific rationality. In our case, this means that IP rights are subject to monofunctional interpretation, and especially to the economic logic. How comes? The property logic or the economic logic is deeply engraved in TRIPS, since the intellectual property system was linked to the World Trade System with the TRIPS agreement. What does property logic mean? It means that according to this logic, new forms of use are automatically subjected to the authority of the rights holder. So every time you discover a new use of an old protected work, the right to use this work under the new circumstances is allocated to the rights holder. But why? What legitimation? It's a property logic, and that is deeply entrenched in the TRIPS agreement. It is entrenched in the three-step test, in the so-called three-step test, that is not only in the TRIPS agreement, but from the TRIPS agreement it moves into the European Union Information Society Directive, and from there it moves into national legislation, and there binds the political autonomy of the national legislator. And what does it say? It says the member states shall confine limitations or exceptions, to the exclusive rights to certain special cases which do not conflict, important, with a normal exploitation of the work and do not unreasonably prejudice the legitimate interests of the right holder. So you are in the position of a national legislator who wants to establish a new limitation or exception to intellectual property rights, then you have to comply with this rule. Where is this rule interpreted? Well, in the adjudication of international dispute resolution bodies, and they interpret this second criteria, normal exploitation, in the sense that it comprises not only actual but also potential effects that have to be considered when it comes to assess the impact of this limitation towards the individual rights of an author. And so what the tribunals do, it's perfectly in line with the logic of the TRIPS agreement. They give them a kind of dynamic reading that adapts to a new technological environment, that adapts to newly created markets, but only under a kind of asymmetric perspective, because conflicts cannot be used, conflicts between users and property rights owners, in an impartial way under such a biased regime. The forum is biased in favor of economic interests. The rights holder are reduced to homo economicus, even if they are artists at the same time, but under this regime they are restricted to their role as a homo economicus. There is no guarantee of equal weight to normativities that you would expect from this broader arena. Are there any ways out? Well, there's this Vienna Convention, and it says that by interpreting conventions, you have to take into account any relevant legal rules that would apply to this case. And there you can think of the International Covenant on Economic, Social and Cultural Rights that says that the states have to recognize the importance of access, but does the WTO panels are ready for recognize these other rationalities? No, they are again biased in favor of their special arena. Impasse? Wait for any further international state action? Answer is no. Civil society did not wait. It began to privately craft IP regimes that preserve the conditions of systemic knowledge sharing. To give you some examples of what I'm talking about open licensing models such as the GNU GPL, I'm talking about open content licensing models such as Creative Commons, I'm talking about massive multi-author collaboration sites. You all know it's Wikipedia. I'm talking about extended collective licenses in the Scandinavian countries, quasi-contractual licenses as proposed in the Google settlement agreement. I'm talking about copyright collection societies, patent pools, standard license clearinghouses, open source genetics, and so on, just to give you a flavor that this arena is populated by these privately crafted regimes. It's not empty. There is an alternative. And how does it work out? Well, they preserve these conditions of systemic knowledge sharing by creating access rules. Access rules put limits on the limitations of use that are implemented by property rights. They prevent the exercise of rights in relation to intellectual goods from undermining the very conditions for the creations of those goods. Right? That is the idea of the access rule, and they do so by moving the selection authority, in the words of a famous economic scientist, they move selection authority to the observation capacity of users. And thereby, these privately crafted IP regimes can become responsive to the operational logic of collaboration between users. They create, in a way, project-specific commons that